We're going to get started. This is just really an informal discussion about the spousal support and child support guidelines and going above the cap and really just sharing our experiences in the cases that we're working on and in our collaborative and mediation practices and litigation practices for some of us. And Alan, who practices in all different areas, could and was able to kind of deliver some perspective from his vantage point, from his practice, as well as what the case law has been, what that's how that's presented, and to share a little bit and get some insight. So we really welcome just an informal. This is, just join in and let's just have a discussion and help each other and support each other on these issues that are certainly really challenging and could, to help us really settle our cases in the best possible way. So, Alan, did you want to, and I welcome
Sure.
everyone. We have a really great, so nice to see everyone.
Nice to see all of you, and I apologize in advance because I could not get out of a court appearance in Rockland County, so I'm going to have to skip out a little early on this. But uh, I've been reviewing all of these cases for quite a while, and one of the advantages was in the last presentation that I did in the child support and maintenance realms, we talked about imputation of income. So it's very interesting that all of the cases that are referred to have some really wonderful explanations on the Child Support Standards Act and what the courts look at in awarding over the cap. So what's the cap? The cap has changed. The cap has now been changing every 2 years, and it's based upon a cost of living analysis. So effective March 1, 2026, and we have to be cognizant of this in our agreements and even maybe looking at our past orders to see if we have a basis for modification. The cap was raised on child support on the combined income of the parents from $183,000 to $193,000. On the maintenance end, the payor's cap was raised from $228,000 to $241,000. So obviously, it's a little too early for us to see how this is going to affect the court in the cases that are issued. I see Melissa's listing some of the cases that
Yeah,
I'll,
I
I'll be
just put it in.
talking about.
Yeah, you should have gotten something this morning with some of the cases that Alan is going to be referencing, but I put it in the chat for you to reference as well. Sorry.
So with respect to these increased caps, we're going to see higher presumptive awards. And this is even before the courts get to the question of what to award over the cap. And in this area, we have seen over the years, the courts are all over the place with caps, with varying county to county, judge to judge, case to case, family court, Supreme Court. So how do we really get a handle on this? So first, we look at what the discretionary add-ons are in both areas. So the court looks to factors in paragraph F of 241B and Family Court Act 413. So we'll talk about those factors in the cases. But what this practically means with the raise in the cap with respect to child support is that another 10,000 in income for two children translates into another $2,500 a month in total support before it's apportioned between the parents. The maintenance change is equally consequential. The 241,000 is also subject to the court looking at the discretionary factors over and above, and there are 15 discretionary factors there. So the expanded cap on maintenance really means that middle and upper income folks are going to be paying more. They're facing a bigger slice of their income being paid out. So that's basic as to what we know now with respect to the increase in the caps. So I think it's instructive to look at the past. And I've got recent cases which I've looked at in the imputation of income aspect, but now every one of those cases and some more cases really apply to the expanded cap and how courts deal with this income over and above the expanded cap. So the first case, and I think I talked about this in the imputation of income area, was MM versus RM. And I like to always look at, we're in Westchester, some of us, so I look at what Westchester judges have done. So this was Judge Patel in a very interesting case. But when she got to the point of discussing what child support obligations would be in that case, she reiterated the factors under the Standards Act, which it's a three-step method for determining the amount of each parent's contributions. So if the parental income now exceeds 193,000 for child support purposes, the court can apply the statutory percentage to all or part of the additional income. But very important is that a court and we as practitioners need to look at these factors and really decide whether these factors are practical under the circumstances. So the court has to articulate the reasons for the choice to go over and above the cap. And Judge Patel here said that it reflects a careful consideration of the stated basis for its exercise of discretion, the party's circumstance, and its reasoning why there should not be a departure from the prescribed percentage, or there should be a departure. And the court must, if it's going to deviate or not deviate, it has to state and analyze the statutory factors. A lot of the cases that I've seen, and I don't know if all of you have seen these cases, it looks like it's just a recitation of the factors, and the court says, I'm using my discretion to determine that this is the amount of support that it should be. And I think that does a disservice to the statute and a disservice to the litigants. So if I could just relate that quickly to our collaborative practices, and Melissa and I have talked offline, and we've had some offline conversations this morning. It just seems to me that the role of the financial neutral is essential here. I think during the imputation of income presentation that I gave, I talked about the Sykes case, which I kind of use as my talisman to come up with how we approach support. I think we've all seen that. It's a really interesting case, but it's 2014. So it's actually before the guidelines for maintenance and child support came down. I think those came down in 2015 and 2016. But there, Judge Cooper did a wonderful analysis. And I think that's kind of relevant to how we should do this in our collaborative practices, which is looking at everything, looking at the income, not just limiting the guidelines, statutory caps, not just limiting it to the worksheets that we do that only take into account FICA and Medicare, but really look at and analyze the whole gestalt, if you may, of the party's income, assets, liabilities, and needs. Because I think that's the only way that I can figure to come to a fair amount of support. Now, there's an interplay between the child support and the maintenance, but it doesn't matter so much as in the maintenance area anymore, since the maintenance for federal purposes is neither deductible nor includable in income. So the financial neutral is going to be able to look at this and take us out of the process a bit, because the lawyers can get positional even in collaborative. And as I mentioned offline, some of these, when you look at some of these cases, you'll see the positional points of each party. And one party could be saying there should be no maintenance, and the other party could be saying there's 30,000 in maintenance a month, which that disparity really makes no sense. It can't be that far apart. So if we look at all of the factors, and our financial neutrals come up with calculations and options, not only for the current period, but looking out for a period in the future, which courts don't really do. They'll say maintenance is durational, it's 5 years. The child support's over when the children emancipate. We define emancipation. But that doesn't take care of a spouse who needs support beyond that. So that's kind of my advertisement on how I do it. And I think I'm interested, and I think we're all interested in how everybody else approaches this in our practices. So I can pause. I have some other cases to talk about it, but I think let's throw it out there and let's see how everyone deals with it in their practices. Anyone?
I'll go.
Teresa?
I mean, this just harkens back to my mediation training, where before I even go near formulas, I like to just look at what are everyone's post-separation expenses going to be and compare it to the income and try to help them figure it out. I mean, I'm very primitive. I've tried the monitor and the, you know, and the spreadsheets, but it's magic marker on a big whiteboard, and people look at it and say, sometimes now I see what I have to do. And I like to do it before we go to the formulas because people can get anchored on formulas. And then, you know, then you have a problem. So.
Yeah, I'm with you, Teresa, on that. How do you treat taxes, federal, state, city, when you do that analysis? Do you take that out to make a determination of what actual sums are available after taking out all of those and you know, that's again different from the statute. Statute doesn't take that into account. There are presumptions.
Right.
Yeah. So
yeah, but I take them out. And then, of course, we then later on will say, well, your discretionary contributions to your 401ks maybe can come back in. A court would do that, but you know, just when we're trying to figure out how to make ends meet.
And how do you deal in cases where you have significant assets of the party who would be the recipient spouse on either child support or maintenance? What do you do there?
Well, so that's helpful, you know, but I mean, I think to some extent we try not to touch it because obviously if you're going to be living on your assets, you may run out of your assets. If they're significant, of course, that's different, but you know, we'll have a conversation about it. And that can be in any kind of case. It's harder in contested cases, in adversarial cases, to get buy-in on the other side, to thinking that way, to thinking practically, but.
My practice has been, and I'm interested to see what everyone else does, is really look at the assets and see what actual liquid income results from those assets. And it would be available for income purposes. And I think, you know, that's really stressed by Judge Cooper and Sykes. I'm not looking necessarily to dip into principal, but look at what's available from dividends and interest from accounts to try to get the recipient spouse up to a point where they might have to use some of that income instead of adding it onto the principal in their assets. So the next case I had was Costello.
Before Alan, I just
okay.
Andrea's hand is raised.
Oh, I'm sorry, I didn't see it. Hi, Andrea.
Yeah. Andrea, you're on mute. All right.
And we don't see you.
Yeah. Okay. Well, maybe when you return, join us. All right. Go ahead.
I'm so sorry. I'm on my phone because I'm walking
Right.
around. I'm on the move right now. So I'm sorry. I'm not on camera and had to find the mute button. Hi, everyone. It's good to be here. I never had this time available, so it's really good to come to this meeting.
Good to have you.
So thanks, Alan. So I'm wondering what's happening in people's collaborative cases where there may not have a need for support, but they want support, and their attorney is saying that they should get support because the guidelines say they should get support. But the bottom line after tax income doesn't really call for, there's no need there. There's sufficient income. It's not like there's tons of money left, but it's basically zeroing out. So has anyone had this kind of situation in their cases in a collaborative case? Tell me how they work this through.
Yeah, Lily, you're shaking your head. I don't know if or you know if anyone else wants to kind of share because you're one second. Thank you, Andrea. So how did it end up in the case that you're talking about, Andrea? Was there a resolution or how did you approach it?
No, we're in the middle of it. Actually.
Oh, okay.
And Steve actually is on the case with us as well. And I see him here. He's our neutral.
Steve, yeah. So Steve, what's your approach to that? That would be interesting from.
Well, I don't think I should. I'm neutral on the case, so I don't think I should say because there's differing opinions in the case, and Andrea's certainly part of it. So I'm gonna listen, but I'm not gonna speak on this particular one. I don't think I should.
Steve, can you speak?
It's a live case.
Yeah. Can you speak to the points we've raised so far and what you do in your role as a financial neutral in helping determine appropriate child support and maintenance?
I like what I heard here, and I do agree with what is in the Sykes case. I always do that. I try to take a look and see what's a reasonable amount of income that comes from the assets, and that goes to taking a look at what the total resources are for the recipient. Some people do feel that they should zero out because the payor has it too, but I don't see how that makes a difference. The whole point in my mind of maintenance is to make sure that somebody is able to support themselves and it's rehabilitative in some respects too. But if they have enough resources from their wages and their investment income, maybe they need some supplement. But I don't think the whole idea is to have them have a huge bottom line afterwards. I think the big question is really if it ends up being a difference in lifestyles afterwards, right? But somebody has an appropriate lifestyle. Do you have to maintain exactly what the lifestyle was before? Or if it's rehabilitative and to help you get to be independent on your own, at what point do they have to have exactly the same, or can somebody be living a much better life than the other? Is that okay? That's where I find the rub. So it's really, I try to make sure they at least have enough to meet their budget, but the question of over and above that, I think there's a discussion. That's where people get hung up.
That's
So
where,
Lily, yeah, go, I'm sorry. Go ahead.
yeah, I'd love to hear from Lily too, but that's exactly the situation here. If they can maintain their exact budget, maintain their lifestyle, but and the maintenance would be sufficient that they're receiving and all their income would provide for everything that they need. Is there any rationale to say yes, but the formula says there should be support, so there should be spousal support just because?
Lily, thank you, Andrea. Lily, did you want to share?
Well, I think everyone's hitting on it. There's so many nuances to this. It could depend on one person staying in the house because of the children and having greater expenses. And even though they're being met and the overhead is higher, would they have stayed there for other reasons? So I think it's like an onion. You just peel it apart to see where the sense of I'm not going to say fairness, but where it becomes equitable in the sense of a lifestyle, to Steve's point, and to the point of, does one party post-divorce have the opportunity to replenish everything they may be using to sustain their lifestyle while the other party doesn't? That's a whole nother question to it too. So I think, it's a case by case sort of analysis of when you're at that point of where maintenance doesn't calculate, of looking at everything else. And
What do you
I think
mean,
it's hard
Lily?
to give a black and white answer to it.
When you say maintenance doesn't calculate, what did you mean?
When you come out where neither party, where they're sharing custody of children, where they're, where the maintenance, the incomes look fairly comparable, so that there's no result for a maintenance payout.
So I think that also raises the question, we talked about this offline with Lily before we started. How far out do you go with this lifestyle analysis? Let's say maintenance ends in 5 or 6 years. How much beyond that period and beyond the period of child support do you look to help a party with less be able to continue to live in a reasonable style, as Steve said that he feels should be done? How do we do that from the analysis standpoint of a financial neutral, or do we do that at all? Do you feel that it's your obligation to do
Steve,
that?
I'd love to hear you. I think it's dangerous. I think it's really dangerous to put projections in front of people unless they are absolutely crazy for it. One, because there's no reading of the future. I don't have tea leaves, and every assumption that goes into that, I can bet bottom line is going to change the minute they're divorced. So I would say projections are useful for guardrails, for showing that there are different sources of things that happen at different points in time, and that every assumption is malleable. I mean, even a 1% change in any assumption is going to hugely impact a 10-year, 25-year projection. And I can remember going to court and testifying for this poor lady on longevity of assets and telling her that she runs out of money at 72, and she went white. I mean, literally white, and said, "Oh my God, do I need to die?" And I went, "I hope not." But I mean, that's the reaction. People look at numbers and they think they're carved in stone.
Yeah.
And so it's terrifying for a lot of people to do that. And Steve, I don't know how far out you go, but only when it's absolutely like the last gasp to do it.
Yeah.
Well, Yeah, oh, I just wanted to share just Lily, because you did that on a collaborative case that we're working on, and
There's an entire crowd here, so.
oh
I'm-
yeah, and the
I'm moved.
reason why Lily did that was that because there was a high, it's like a high income, they may have like 10 million, I think, and then there was this proposal that just divide up and there's no spousal support that's going to be needed because you have enough to live off of your assets. And my client was just like, no, like I'm really concerned that I'm going to run out, in 5 years or whatever. So Lily did an analysis, which I think was helpful because it illustrated that there was a degree of longevity, but there were choices that she had to make, and that really informed decisions in terms of how to approach, buying a house, renting, or where she's going to live. But I do think it was helpful as a guardrail, but helpful just to illustrate whether no support with a high income. And that's the challenge that I'm facing with many cases when you have high assets and, oh, well, we have enough to go around, there's no support. And then it becomes, I think that analysis becomes important to do.
So I'd like to
Go
answer
ahead, Steve.
the question about projection. I think the first thing to be aware of it is every year further out you go with projections, the weaker and weaker they are, because there are always assumptions, and it's real life. Just like budgets, it's a very dynamic type of thing. And I think also that projections don't take into account there are natural things that you do. If you hit a downturn in the economy or in your life, you make natural changes yourself. And I always discuss with clients, even if you had stayed married, right? Would you not have made some adjustments along the way? The idea is not to put you in better footing than you would have been if you kept on going the way you were, right? And so things happen in life and you have to make a change. And so if you did have a medical event or something else, you're probably going to stop the travel, right? And so there'd be other things that are going to happen in the budget that go away. So it's weaker. I do think it's just helpful, a general thing, like people want to know, is this going to last me? That's the classic question. How
Right.
long is it going to last me? And there's no guarantees. I will say that some financial advisors do use so-called Monte Carlo analysis and tells you different probabilities of success. A lot of times people only look at the success number, but there's much more to it than that. And make sure that people understand if they're talking to a financial advisor, they'll always point to, well, the likelihood of X percent of the time will be working, but you should really take a look at the worst case scenarios and take note of those. It's less probable to happen, but it will still it's still something to understand. People don't really know exactly what they're looking at. And again, on the back end, right? So if something lasts to age 90 versus 87, I don't think we could really plan for that level of precision. But coming back the other way, but people want it, but
Right.
you can't do it. And you make natural adjustments to your portfolio, the way you spend, and so on. And to Alan's question, though, I think it's more, should somebody's lifestyle change dramatically after year 5 or year 7? And maybe part of you have to do is you have to build in a way to taper things off so it's not a sudden shock. I think we try to look and see if you can anchor it to when Social Security kicks in. So sometimes if you have something where it should be a 10-year run, but if you take it to 12, then you link it in with the Social Security. So that goes to what Lily said before, is that you have to look in the big picture. I like to do a timeline at first and see key events that are going to happen in family going forward. And that might be something to strive for at certain events. And of course, I think the last thing is, I do view a maintenance as rehabilitative. I think that's part of what it's supposed to be. If you have somebody who could work, how long will it take for them to get there? There are some people who can't work, and that's much harder, or the prospects are much harder. So those are all the considerations, but there is no cookie cutter approach. And I don't think there should be. And that's why if you follow the statute right, it's intended that there should be a cookie cutter approach. Yes, they can cite all those factors, but the whole idea is to be thoughtful about it and giving ideas. And even with all the factors, the last factor is, and all such other things. So it's really, you can consider anything, right?
That's right.
Right, and that's what we should do. Teresa.
So we've talked, some of us, about this, having like check-ins with people 6 months or a year down the road. And sometimes what happens in the future is really fascinating. And I recently heard from a client, it was not a collaborative case, but she had a financial neutral and she had somebody sort of like I guess you would call a family specialist sort of coordinating it. And we had a terrible lawyer on the other side. And we fought for every penny, and we had decisions like the husband was 67. How many more years was he going to work, even though she hadn't worked and would be entitled to, a long-term maintenance? And what was she going to do? And she was not happy with the resolution. She felt pressured into it. And now, like 8 years later, she's in her late 60s developing this incredible business. She's wildly happy. Everything worked out really well, even though the husband's still working and he merged and he probably made a lot of money with this firm, whatever. So that was interesting. But getting back to the original question about, do you have maintenance when there's lots of assets? I had a collaborative case many years ago that fell apart. And the financial neutral said, okay, you're getting these millions and millions of dollars, but you've got 4 kids and you're only this old and you really need maintenance. And that was sort of where it fell apart and then ended up at the Court of Appeals, but that's another story.
One of the other things, Steve and Lily, that I would raise is we take into a lot of the assets in our cases are retirement assets. And then we have to deal with, if you're looking down the road, there are the RMDs at a certain point in time that must be taken by the party who needs more support. And that, I guess that's part of the picture that you're going to paint when you're doing your analysis to see what's available post-maintenance and post-child support. So I think that's...
I don't know. I think RMDs just tells you have to pull it out of the IRA 401k structure. Doesn't necessarily mean that you have to spend it. You have to recognize the income, but the asset is still there. So what you do with it is another story. I think one of the things I try to do when we talk about RMDs, and people tend to not realize that their incomes can be higher, that they have to pay taxes on starting at age 73 because they put off when you have to pull out the RMDs. That means each amount that you pull out each year going forward is going to be much larger than you thought. So you might end up in a higher tax bracket. There's other implications because with Medicare, for those who may be on Medicare already, or you've seen it with some of your clients. So there's a so-called IRMAA surcharge, which is a fee. Everybody has a certain base amount they have to pay for Medicare, but then there are extra bands that's tied to your income. So if you can have this larger amount of income all of a sudden coming out from RMDs, it might make things much more costly than you think, because whether you call it a surcharge or a tax, it's a tax, right? And so there's more money you have to pay. One of the things that I try to look at is if you have the recipient of support, and there's a lot of IRA income there and 401ks, those might be some people who are a great person to do a Roth conversion, if you're familiar with Roth conversions are, because you have people start at a very low level of income. Let's say, especially right after divorce, if they have some IRAs, you can do some Roth conversions. Then number one, once things are in the Roth, you don't have to do RMDs anymore. So that's a whole other question. You could have same balances in a regular IRA and a Roth IRA. One person has to pull money out because of the RMD rules, one doesn't. But also, if you pay the tax with the Roth conversions, you pay the tax to make it a Roth during a period of time when their incomes are low, then it gives you some flexibility later on and save you later on. So I think that needs to be holistic and just be aware what happens at different points in time. And I think we see a lot of cases now with these questions like RMD and Social Security and so on, because of the fact we have silver divorce, gray divorce, many more people where the run of maintenance is going to butt up to retirement time. And also, I've seen in a number of cases, should somebody keep on paying maintenance how long do you expect them to work? So all these things are coming up. And so they will have to be taken a look at in total.
I think that topic that you last raised is a whole topic that we can have a pod on or a presentation on.
Next month, Alan, we need a topic. So that's it.
But it comes up. That's the theme, that I see.
Yeah. No, I agree with you, Steve, because I see all the time gray divorces where the parties are close to retirement, and how much, if the guidelines would say a 15 to 20 year maintenance period, that's not practical. It's not going to happen in court anyway. So how do you deal with that with parties differing expectations? So again, I think great point, and something for the future. So let me do some criticism now of cases. A la Tim Tippins. The Castello case that I talked about before on the imputing income. Again, we have these factors that are supposed to be discussed in cases, And this is the Appellate Division First Department, looking at a Judge Katz decision from Supreme New York. And all the Appellate Division says is the trial evidence reflects the parties live a comfortable upper middle class lifestyle, and both parties have significant resources to support the use of a $250,000 cap. Well, that doesn't look at any of the factors. That's just the court saying, yeah, we think the judge was okay with that, but it doesn't talk about any of the factors. So it's very frustrating. And I know we've all sat through the Tippins presentations, and we hear that what we get from the courts is unsatisfying, especially at the appellate level. They write, one page or even like no decisions affirmed. So I think that's more important in our collaborative practices, that we want to avoid court, because you don't know what you're going to get, and there's so much discretion from the trial court judge. The appellate division doesn't really look at it very hard. So it is important that we continue in the collaborative practice and do it the way Melissa, I see your hand go up.
Yeah. So is there cases that talk about the tax consequences because of the statute being before the tax code change? Is there a consideration of that factor?
I haven't seen the recent cases that I've looked at talking about the tax consequences. I think the older cases certainly do, but there was that period of time, and I think we all remember that, when the change was made in 2018, that we had to get our agreements in before the end of the year in order to preserve the tax deductibility. And that was a nightmare.
Oh my God. Yeah.
But now there's less of that. I remember working with Steve on a case. We're talking about adjustments based on now there not being taxes, and adjusting what the maintenance and support ought to be. And that I just think that kind of went by the wayside after a while. It was a whole hue and cry at that time, and that went by the wayside. So, I'd like to hear people weigh in on that before I talk about a family court case.
Yeah. Rosalia, do you want anything to share as a financial neutral, your perspective?
I mean, I'm taking in, I agree with a lot of what Steve and Lily are saying in terms of projections. I've had quite a few cases where there was a lot of assets, like millions in assets, but one of the spouses was still working, albeit towards the end of his career, and the other spouse wasn't, and felt entitled to having some type of maintenance. So what we did was kind of show different amounts of maintenance and show that the maintenance really wasn't needed because of the income that was being generated from the other assets. And I find that helps. I think that if you project too far out, there's always going to be one spouse that will show a reduction in income, especially in those scenarios. If one spouse isn't working, their assets are going to go down eventually in comparison to the working spouse. And that's always cause for disenfranchisement, if you will. So yeah, I agree with not projecting too far out into the future. So if that makes sense.
It does, thank you. So I talked about the Supreme Court and Appellate Division. I have a family court matter now that has been going on for a number of years, and I just got brought in the case, and I see a decision that was issued by Support Magistrate Cabanillas Thompson, who I think is not in Westchester anymore. She might be in New Rochelle, I'm not sure. But this was a case where there was over the cap income, not a lot, and this is when it was $154,000. And her take was that in the higher income cases, the appropriate determination for the court under the Family Court Act, and that's 413(1)(f) that has the factors, for income in excess of 154 should be based on the children's actual needs, and that the amount of support that is required for the child to live an appropriate lifestyle. So that's a very limited analysis, but then she went on to say the court has considered the children's modest living expenses, resources of the parties, and tax consequences, and then decided not to go over the cap. But again, that's not really an analysis. I considered it. These are the factors I considered, and this is my conclusion. So I think, again, we're lacking in getting the guidance that we need from a court to look at all the factors and analyze them properly. Now, some of the cap cases, and I think we talked about these when I did the imputation of income, which were interesting. The first one that we looked at was the AGGS case, and I think these are both Supreme Court New York County Judge Chesler matters. And it's interesting to look at how the court determined child support. So these were temporary awards, but we know that temporary awards of child support, we're not bound, judges are not bound by the CSSA, but they usually do the same analysis under the CSSA. And here we had income of about $400,000, and the court capped it at $300,000, without doing an analysis, and again, with regard to the maintenance, doing the same type of calculation without doing an analysis. The GB case was the interesting case that we spoke about on the imputation of income. What happened there was, even though it was a temporary support order, the court looked at the caps, and there was an income there, and they went through a whole determination of whether capital gains income should be included in a party's income, and concluded yes. Then analyzed a few years of income taxes and determined that the amount, and there's a lot of assets there. There were like $13 million in assets, but they used income of about $1.5 million, and then went into an analysis without really going into detail of all the factors, and said, by way of discretion, the cap is $650,000, which is a pretty large cap. And when we look at caps in our counties, we usually don't see these caps. But within that case, the court cited some other cases. In one case, the Clower case, an $800,000 adjusted cap. So what do we do with these caps? How do we deal with them? How do we deal with them in our collaborative matters? And I think in this discussion so far, I think we've gotten to a really good place of saying, we could throw a lot of the analysis under the Child Support Standards Act, whether the number is 183, 193, whether it's 228 or 241 on the maintenance. We look at this in a very analytical and practical way to see what's available for support, what the real reasonable needs are of the parties, and then come up with options. And I know the financial neutrals has kind of echoed that. And I think that's really the point. And I want to know how everyone feels if that's where we are with this.
Sherry, I'd be interested to hear from you too. You're you're more northern in your county, and you do a little bit more of the litigation. Do you want to share any from your perspective, practicing up in the northern suburbs, how you approach that?
So interesting. I'm doing no litigation. Please mark that down. None.
Good. Yay.
How about from your recent past litigation, Sherry?
I'm doing mediations, and I'm trying to get collaborative law into Orange County. Kicking and screaming. It's really hard.
Okay.
Interestingly, up county, Dutchess County, we have many cases that are above the cap. I tend in my mediations to, again, do the needs analysis looking, and it's interesting practicing in Westchester for so many years. Dare I say I'm giving a blanket statement. I've only been up here for about 6 months, but I'm finding the parties are really looking at their needs and figuring out what it's going to cost going forward. They're a little more amenable to that. And certainly in the mediation cases, it's working. And they are, again, there are significant resources above the cap up here in Dutchess County, maybe a little less in Orange of the cases that I've had. But I think, looking at what it's going to cost going forward, we're really doing that. People are, dismantling their households. Quite frankly, they're renting quite a bit up here. We're getting 2 rental properties as opposed to one party staying in the house because they are capturing their equity. Mm-hmm. And then we're looking at rental requirements above the cap. I mean, we're not stratospherically above the cap in as with the cases you're talking about, marginally above the cap. But even above the cap, the needs are for both parents who are, primarily doing an equal parenting split. All the money's going towards their living expenses, even above the cap up here.
Thank you.
And
So
again,
I think
no
go ahead,
litigation,
Melissa.
none.
None. We hear you loud and clear. Yeah, we're
Thanks, Sherry.
Yeah, Jonah, I'd be interested. You're the only MHP, I think, in this room. Like, what perspective do you bring to the table, and what would your role be when you're kind of helping with facilitate this discussion? Oh, you're on mute. No? There you
No
go.
longer on.
Okay.
Hi, everybody.
Hey, Jonah.
So in more recent time, it actually the last number of years, I used to do, before mediation, I think became much more popular. I was doing both ends of it, but then I realized there's so much I don't know that I often defer to a financial neutral to sort of organize the material. And oftentimes what needs to happen sort of falls out of that discussion, and it makes it easier for me to step back and use the financial neutral as a person who sort of puts the issues on the table, and then I can sort of help people move from there. And they also usually talk about sort of what the norms are and what should be expected. And so I have actually found that a much easier way to go. And then I don't personally have to get involved in those questions, which I think it's helpful in terms of being able to stay neutral and sort of help people figure out sort of where to go from there.
Thank you, Jonah. Does anyone want to share any input on anyone who hasn't spoken? Arnold, Adam?
Well, Melissa, I can talk about our case a little bit.
Which one?
No,
So in
no
that
names,
case,
Arnold. No names.
Without going into I'm not going to mention the names of the parties of court, but in that case, I have it's a childless marriage, and my client has some disability, but a frugal lifestyle. He's
Very
agreeable
frugal,
to
very
going under the maintenance cap, not following the guidelines for maintenance, taking less. But we focused on the needs, and he has a frugal lifestyle, and we tied it into what his share of the pension money is going to be to come out. We've reached a meeting of the minds. You want to comment on from your perspective, Melissa, on that case?
Yeah, no, it was definitely Arnold, your client was incredibly frugal. I mean, that lifestyle, both of them in that way, and that I think helped. But I think what also helped is that they really they were separated for like probably 15 years before entering into a collaboration. So, and there was this chronic illness that Arnold's client was suffering from, and my client was really his primary caretaker, which was a really special and important relationship to preserve. So while my client made a decent amount as a teacher, it only goes so far, and it was very limited, and she also had some extended family living with her and other it just was limited. So we were able to really kind of reach a resolution, really focusing on needs with also the opportunity to help out in other ways. Like once a year they would go to like Costco and buy like all this stuff, and we built that in. Like it was just
the medical needs.
Yeah, it was very real, and it just made sense in that way. And also, it was just really keeping it really real, and what was actual, and what was most important was really preserving and protecting that relationship, because I think that always she's going to be there. And I think if we were going to be put in a situation where we were going to apply the guidelines, I think it would be a really difficult it would be really difficult for my client to manage. And I think
Also, your client has very substantial credit card debt.
Yeah, well, yeah,
which I
shows-
certainly took into,
which
or my
shows that
client
they
took
were-
into account.
That's right, which shows that they weren't even meeting their needs. And that's just a whole other thing when you have that substantial amount of credit card. And yeah, so it was really focusing on needs and concerns and what mattered to them. And what mattered to them most important was their relationship. And I think that that was a really compelling reason why we were able to reach that resolution. And I feel really good about it. I think, when we're looking at it from that perspective, just looking at it from a numbers perspective, just wouldn't work for this couple. And I think we always need to be mindful about asking really what matters and what's most important. Having those interest meetings, options is just a really important piece of developing packages in the process, and not to kind of miss that step.
Agreed.
Great points.
Yeah.
So
Adam?
there are just two
Oh, yeah.
maintenance cases that I cited, and I've got to jump because
And then
I
he
have
has
to
to
head
jump,
over to
too.
court. But they're both Judge Chesler cases from 2025 in Supreme New York. And to illustrate what I was speaking about before, the parties can get very positional. In the SA versus JA case, the statutory cap of maintenance, of course, then was $228. It would have yielded $2,100 a month to the husband in maintenance, but the husband asked for $20,000 a month in maintenance, which the court said, no, that's kind of ridiculous. So it adjusted the cap with income. The wife's income was over $300. The husband was imputed $80,000, and the court said, I think $325 is the proper cap here, and it yielded $37.50 a month versus the $20,000 that he was seeking. And there, Judge Chesler actually went over the factors, looked at the standard of living, the age and health, the wife's historical position as breadwinner, the wife's position of having greater access to economic resources, and the husband's long-term employment without reasonable income. So I don't know if either of these cases went up. I haven't seen whether they've been appealed, but so I think it's interesting to look at that in the context of our discussion on the maintenance cap being raised from 228 to 241. The one thing that we're sure of that I can leave you with is that the court is going to look at these new caps as the floor. Mm-hmm. And we're going to be dealing with the same type of arguments on ceilings in court and then in our collaborative practices, see what the ceiling is. And again, I would just stress the financial neutrals are the most help that we can possibly get in these cases to reach reasonable support determinations. So yeah. I thank you all.
Oh, you're leaving?
I got to run. I appreciate everybody's participation. Great session. And we'll try to come up with some new topics.
I think we already have one, Alan. So
I know we do.
Be in touch. All right.
All right. Bye all.
All right. So, bye-bye. Thank you, Alan. And by the way, the cases are in the chat, for everyone to see. Everyone should have it. Adam, did you want to share something?
Yeah, thanks, Melissa. This is a great presentation. And, I think a lot of us have seen these cases, but we'll, look at them again in a new light. And just to, build on, some of the things that are already being said by, Sherry and Rosalia and everybody else, is that, sometimes the resources are already there in terms of finding someone who is a financial neutral. So in a number of cases that I've had recently, and I'm not sure why this is, but it seems to be a pattern. People often, when we're talking about needs, which is often how I approach this and these kinds of questions, they'll talk to like the accountant or the financial advisor that they've basically had for the last 20 years and kind of use that person because there's already an extraordinary level of trust and belief in their knowledge and wisdom and all of that. And once it comes from that person, whatever it comes, whatever information or recommendations, whether it be about RMDs or anything else, going back to what Steve said, I have to say it's incredibly helpful. It's kind of like a silver bullet to have someone who's already been present, as opposed to, I know all of us like very often are coming to things new and we're meeting these people brand new for the first time and then, proposing experts of various kinds. Sometimes those experts are already in the family constellation and it can be super helpful. I'm not saying it takes the place of anybody on this screen. I'm simply saying that they can be a resource towards these questions.
Yeah, and in fact, that's a great point, Adam, because I know I recently had a mediation where they actually bought in their trusted financial person, their accountant. They were like part of the mediation. And it was really incredibly helpful. Just, they really trusted them and listened and from their different perspective, looking out for their interests in a really holistic way. And it really helped, in that way. Jonah, and did you want to share? Were you raising your hand?
Yeah.
Okay.
I have a question. how do people sort of think about this? When you have a spouse who has some degree and training and ability to work, but hasn't worked in quite a number of years. And usually I find if there's a number of years that people are sort of out of the workforce, they have so much anxiety about going back, like really like terror. And oftentimes there's a real question of whether they will be able to get back into a workforce, and certainly to earn what one might expect that they can earn if they have a law degree, if they have another degree that would put them in a much higher earning position. But they are so anxious. They feel like they have missed so much. The world has changed so much. They can't sort of get back into the workforce. And I wonder how people sort of think about what kind of income to impute to them, if any. They've been supported now for a number of years. Have people had situations like that, and sort of how do they sort of think about it? Do they imagine that that person would be able to earn some kind of reasonable income using their degree? Or is it more along the lines of sort of taking some job? I work in Katonah, at some local store in Katonah, and they'll make that kind of income, which is where some people sort of start. But the terror is really quite profound, and I don't think it's just as a consequence of divorce and they're sort of working in that way. I think they really are just terrified. They feel completely unable to mobilize themselves to get back into a workforce.
I can speak to this.
Oh, yeah, sure. Who is that, Andrea?
Yes, I'm in my office now. Hi.
Yay.
Okay.
Good job.
Yeah. So yeah, and it's actually another collaborative matter I have right now. And in this case, the husband was a former doctor and had not worked in this line of in medicine in this area for might have been like 20 years. So in this case, he's no longer going to be working with the wife in her business. So we agreed to impute some income to him. Definitely income from all the assets that he's going to have, future income from Social Security when that comes into play, and and then there was another I think we agreed on $80,000 imputed income because he should go make the money, and he agreed to that. So we don't know where that other 80 is coming from, but he took that on and he agreed to that. So like I said, it's collaborative, and it was challenging to get there, but we got there, and I think it feels fair. So it's more than minimum wage job, but it's less than, what he could have earned if he stayed in that line of work, which he didn't. And he couldn't go back to it at this point. He's about 60 years old now. So that's how we handled that case.
I'm just going to add, I think it's really noisy here, so forgive me, but this is a bigger question than imputing income. This is a really very big question because it focuses on a complete change in lifestyle expectations. It's age related. It's a whole ball of wax. And to sit with clients that face this prospect of what they've done for the last 30 years in a marriage versus what they have going forward, and they're in their late 50s or 60s, it's a point in time where you reach out and find out as much as you can in terms of support resources for them. And it's not just a vocational assessment. It's more than that. It's it's their health, it's their children, it's their relationships, it's where they live, it's where they found, a community. And it's pretty deep. So if you've got someone, like Andrea just said, a spouse who's willing to accept a mountain of imputed income, whether or not they ever achieve it, that's a home run. I mean, that's sort of like, but it is because they've recognized a loss in a career opportunity that maybe they didn't really miss before, but now it's sort of hanging on their shoulders. And it's a fact of life. So I love those challenges because it really calls to the fore every skill you have of navigating a client for a future that's completely uncertain. I'm sure you do the same, Steve, but it's really a fascinating puzzle because you're putting together a life that
Yeah.
just has to be re-scrambled and re-put together as as a picture for them to buy into, to say, yeah, I'm going to have confidence in this.
Mm.
And that's what you're trying to achieve, is their sense of confidence in it.
I come back, I think everything is holistic and there's no cookie cutter approach.
Right.
So we're just learning about the things you have to, the question you have to ask to size the people up. And we each have different inputs as a team. It's take advantage of the team members. Like it'd be helpful, you would ask Jonah, what are the key things that you're hearing, and does this person really have the ability to go back or not, or all those type of things. Everybody has different inputs that are helpful.
I've been involved in a couple of cases where one person was an attorney and hadn't practiced since they got married. And then I had another case where the woman was a CFA and had not practiced. And at the time, this was litigation, but Rona Wexler came in. And I know, obviously now she's retired, but she really gave a lot of good input and to the client in terms of where she could go. I've also referred some clients to vocational experts who also, are able to interview and assess, where the person can start. It might be something totally different from what they were doing before. So I agree, it's definitely holistic, but I think it's very difficult to look at it, just what's in front of you, because a lot of times, especially when you haven't worked that long, it's a daunting task and it can be extremely emotional for the person that you're working with, because they don't know where to start.
Yes.
And they're relying on us to give them recommendations of how to start and where to go.
And having somebody to really give them a vision of how they actually could start in a way that would feel doable in some ways, sometimes can help people get off the dime. And I do think it's different in a family where there are significant assets versus a family where, in my experience, the anxiety, I usually see those cases where the wife is the one who has not worked for a number of years and is quite anxious about going back. What was I going to say? I lost my train of thought.
I was going to say the Long Island Pod last week talked about how difficult divorce is for a lot of people. And what you're talking about, Jonah, really underscores that a little bit. How much emotional difficulty are people having, and how are they able to move on? That's the people in those positions probably are the ones who are having a lot of trouble thinking about the future. And then I'm going to, confess I'm really guilty of saying I'm imputing $40,000 of income because that's what a court is going to do, which is not normally the way I operate, but and hardly anybody objects to that. And actually the first, I got it from an adversary who I thought was unreasonable, did it a number of years ago. I'm like, oh, okay, maybe that's a standard. So maybe that's okay.
Anyway, all right. Well, listen,
this was great.
Thank you everyone for this great conversation. Just want to remind everyone, next week we're screening with the filmmaker in person, the Splits film in New York City at where Andrea Vaca's building. Not that you own it, that is your building. Where
it's her building.
But that's how I refer to it. But it's across from Grand Central, and we're having a filmmaker, which is amazing, on the 2-part on Splits and talking about
very cool,
which is really cool. So hopefully join us for that. And then the BCIT training that we're doing in May. So if anyone's interested in becoming a collaborative professional, we're doing a training, the basic collaborative training in Westchester in May 14th, 15th, and 16th. So spread the word, and thanks again for joining us, and hopefully, see you next month. Thank you everyone for this great conversation. And in the chat and there was an email about the cases that Alan referenced in his discussion. So thanks again, everyone.